most of the time when you have a written contract in the state of Florida, a lot of people that prepare those, including attorneys, will rely on a certain form or format. And within that form or format, there will be substantive changes that will be made. And then other times there will be what's called boilerplate language, which exists in a lot of the contracts and don't often get changed. There are merger contracts, there's jurisdictional issues, there are alternative dispute resolution, there are attorney fee terms within kind of the boilerplate contract. And in that, you have what's called force majeure. And what force majeure basically says is that if the performance of a term in the contract is impossible via some quote unquote act of God, then the person that is obligated to perform may be excused from the performance of that contractual term. Now, are pandemics considered to be an act of God if they're not specifically listed in the force majeure part of the contract or anywhere else in the contract? Probably. That probably would be considered an act of God. It doesn't necessarily need to be a good thing that happens to be an act of God. Obviously, it could be an earthquake, some kind of natural disaster like that, or some type of pandemic such as the one we're in now. The question, though, becomes what happens when you say, okay, that comes under the force majeure, that comes under the act of God, but does it excuse a particular obligation? And there may be one obligation, but there are usually more than one for each party in order to fulfill their obligations under a contract. Now, before COVID-19 came, the kind of the prevailing philosophy was that the particular term that is being requested to be excused from one party or the other, that particular term has to relate directly to the outbreak. And so if you start getting into less direct kind of issues, such as you say, well, because of COVID-19, the economy suffered, and because the economy suffered, we can't fulfill our obligations. That's a little less direct than what is typically anticipated under force majeure. So to give you an example of what's typically included is on a contract, a real estate contract, and you have a date for closing. Well, so in Florida, we had an issue where we were actually, the government was setting up, certain stop stations at the border, especially from people that were coming down from New Jersey and New York, and there were issues like that. So even with remote closings, it could have presented a problem for somebody not to close on time. Does that mean that you're forgiven for closing altogether? No, because like I said, there could be remote closings and you could do it later on. It doesn't excuse you entirely from the contract. That was before COVID-19. Now, for every kind of question that's asked of me about it, when it's dealing with either association work or real estate or just general business contracts, I will say that this is a relatively unique kind of situation that we're in because most of the case law that has been developed has really in the last 50 years or so, and it changes a lot. But we really haven't had a pandemic like this where you've had a lot of case law. So there's going to be a lot of lawsuits coming because of COVID-19. Some will be on force majeure. I get emails from the federal bar and from the Florida bar on courses to take, and we're going to tell you how exactly to deal with this. Well, they can tell you what's happened in the past. They certainly can't give a really, really strong prediction of how this is going to work out and how judges and arbitrators and appellate courts and Supreme Courts are going to deal with this issue. So that's the long answer. The short answer is it all depends. Can an association get out? Maybe. It depends on the facts. It depends on how a judge is going to look at this. So it certainly needs to be looked at on a case-by-case basis. I really don't feel as comfortable as some of these people that are shooting emails all over, including law firms that send them to associations and say, okay, well, look, this is what you're obligated for and this is what you're not. That's a little bit of a strong opinion given the fact that this is a relatively novel situation that we're in.